is an application and an appeal in the matter of Andrew and the Federal Republic of Nigeria.
Good morning, my lords. As you know, this is the hearing of Mr. Andrew's application for permission to appeal, with the appeal to follow immediately afterwards if permission is granted. The hearing is listed for 2 days. I appear with Mr. Adamic and Mr. Lee. The respondent, Nigeria, are represented by Mr. Willen, KC, Mr. Ford and Mr. Burgee.
Yes.
Can I just check that the court has got all the right bundles? There are 6 bundles in total. There's a core bundle in 2 hard copy volumes, a core supplementary bundle in 1 hard copy volume, supplementary reference bundle in 4 hard copy volumes, there's an authorities bundle in 5 hard copy volumes, an applications bundle in 1 hard copy volume, an agreed documents bundle in 1 hard copy volume.
Yeah.
All the bundles have been provided both as PDFs and in hard copy.
Yeah.
For the electronic bundles, I will provide bundle and page references.
Yeah.
If any members of this court are using hard copy, I'll provide bundle volume.
Well, I've got hard copies just because in a case with this much, it's sometimes easier, frankly.
Right. You also will have EP screens in front of you.
Yeah.
And the Opus operator will.
Well, there's a full Opus transcript, so we needn't worry about taking too much of a note, and also we'll have the documents
exactly.
on screen. Yeah.
So can I just tell you where I'm going to go? First of all, I'll describe very briefly the nature of the appeal and show you a few passages in the judgment. Then I'll address a number of key legal principles in order to lay the proper foundations for the consideration of the grounds of appeal themselves. And thirdly, I'll deal with the 5 individual grounds of appeal in turn. Fourthly, I'll address Mr. Andrew's application for permission to appeal and an extension of time to make the application. I acknowledge, of course, that the application for permission logically comes before the appeal itself, but in the usual way we say the application is best understood against the background of the substantive appeal. And then finally I'll deal with the 4 ancillary applications that are before you in addition to the application for permission and an extension. First of all, Nigeria's application for permission to rely upon fresh evidence. That's 1 short witness statement,
Yeah.
which we haven't seen below and to which no objection is taken by us. Then Mr. Andrew's application to put in a short witness statement in reply, and that is opposed. Mr. Andrew's application to rely on the unagreed documents bundle, that is opposed. And finally Mr. Andrew's application to rely on Andrew 11, which addresses a point raised by Lord Justice Mayles in his order of the 25th of November last year. And subject to the court's views, I'll deal with those applications at the end, and I hope I'll be able to take them quite briefly by that stage. So, dealing with my first point, introduction. By an appellant's notice dated 21st December, Mr. Andrew seeks permission to appeal against 5 specific findings that were made against him in the judgment of Mr. Justice Robin Knowles, dated 23rd of October 2023. The judgment was handed down just over 6 months after an 8-week commercial court trial, at which Mr. Andrew submitted 8 witness statements and gave almost 3 days of oral testimony. In his judgment, the judge found that Mr. Andrew was corrupt, that he was greedy, that he was a liar, and that he had breached his duties as a solicitor. We've referred to these findings as the adverse findings. Mr. Andrew appeals these adverse findings on the basis that they were made in breach of his rights to due process under the European Convention of Human Rights. He submits that these adverse findings were made without supporting reasons and without affording him the opportunity to defend himself against them. And on this basis, Mr. Andrew seeks an order from this court that the 4 paragraphs in the judgment containing the adverse findings be set aside and be treated as if they'd never been made. Can we have up first of all, core bundle page 124. If anyone wants a tab, it's tab 4.
So your client's case, he had no idea that the judge was being invited to make any of these findings against him.
He had no idea that the judge was being invited to find that he was corrupt. And I'll make good that submission in due course.
But I mean, I don't know how many paragraphs of the pleading against him, a sustained cross-examination over 3 days, together with written closings, oral closings, all of which made it perfectly clear what the case was against him, didn't they?
There was no allegation in the pleading that he was corrupt. It was never put to him that he was corrupt. Corruption was used by the judge in the judgment as being synonymous with the effect of bribery.
Will you show us you're going to show us where in the judgment the judge found that he was corrupt?
Yes, I'm going to.
I mean, we got plenty of findings that he was financially interested, so the greed aspect, and we got plenty of findings that he was not telling the truth, which was a matter for the judge, not for this court.
I'm going to come to all of that. If I can invite.
Yeah. Okay. So you want us to look at
take me out
this is the judgment you want to look at.
I just want you to see the four paragraphs that we want to invite the court to disregard. First one is paragraph 214.
214.
Yes. And that's where the judge finds that he rejects as untrue Mr. Andrews' oral evidence that the documents were shared as part of settlement discussions. That's the last sentence. And then 215, Mr. Andrew knew he wasn't entitled to see these documents, and the decision not to put a stop to it, at least by informing Nigeria or immediately returning the documents they knew were received, was indefensible. The reason that Mr. Andrew behaved...
Is that the second finding, or is it part of the first finding?
It's the second. It's, the 215 is our second ground of appeal, the indefensibility. And the money that they hope to make is the third ground of appeal, and the greed, which I'll come on to. Then 216, Mr. Andrews suggested he didn't pay particular attention to Nigeria's internal documents and didn't read them all, or some of those he received completely. That I find was not truthful evidence. And then can we go on to page 208 to 592. Judge finds at 592. This case has also sadly brought together a combination of examples of what some individuals will do for money, driven by greed and prepared to use corruption, giving no thought to what their enrichment will mean in terms of harm for others. I will make good in due course the proposition that this paragraph clearly relates to Mr. Andrew. I know the other side seek to argue something different now. It's not how they interpreted the judgment at the time, and nor how the world interpreted the judgment.
Yeah.
Importantly, none of the paragraphs I've highlighted are relevant to the judge's disposition of the case as between the parties. Therefore, each of these paragraphs can be disregarded without affecting the rest of the judgment.
Well, you say that, but we need quite a lot of convincing about that, Mr. Wardell. Because it seems to all of us that if you start unravelling those paragraphs and those findings about the person who had the conduct of the arbitration on behalf of the IPD, or at least part of the conduct of the arbitration, then you run the risk of opening up the whole, as it were, the whole mare's nest, putting it.
Well, I respectfully disagree with that, because when we get to it, you'll see that the irregularities that the judge found were irregularities on the part of P&ID, and at the relevant time, Mr. Andrew was merely acting qua solicitor. He didn't have an interest in P&ID and didn't become a director in P&ID until October 2017. So before turning to the grounds of the appeal, my lords, it's necessary to summarise briefly what Nigeria's case was against P&ID, where Nigeria's internal documents fitted into that case, and how the judge ultimately came to decide the case in favour of Nigeria. In January 2017, the tribunal awarded P&ID damages for breach of contract in the sum of 6.597 billion plus interest. Nigeria applied under sections 67 and 68 of the Arbitration Act to set aside the awards made by the tribunal. The trial of Nigeria's application was heard before Mr. Justice Knowles from 16th of January to 9th of March 2023. and we refer to these proceedings in our submissions as the set-aside proceedings. Nigeria's principal case in the set-aside proceedings was that P&ID had colluded with Nigeria's leading counsel in the arbitration, Mr. Shasori SAN, in order to secure victory in the arbitration, and that it had unlawfully obtained from Mr. Shasori and his colleagues in Nigeria's legal team various internal legal documents and used them to monitor Nigeria's position in the arbitration. And that can be demonstrated by reference to two short paragraphs in Nigeria's re-amended statement of claim in the set-aside proceedings. Can we look first of all at the call bundle, page 303?
Yeah.
And it's paragraph 444 there.
Yeah.
And you'll see at 4.4, it's alleged that P&ID colluded with FRN's advocate, Mr. Shasori, and or individuals responsible for representing FRN in the arbitration, and or individuals responsible for obtaining evidence for or giving instructions to FRN's legal team, and or individuals directly and or indirectly involved in FRN's defence, including Ms. Adelori and Mr. Oguini, Ms. Bilgori and or Ms. Adarami and Mr. Diko, to ensure that Michael Quinn's false evidence went unchallenged in the arbitration, and or that FRN's defence of the claim was impeded, and or that P&ID and its advisors continued to be furnished with confidential and privileged documents belonging to FRN. And PID was, as a result, awarded damage. And if we go on to page 365, it's paragraph 85. During the arbitral process, P&ID and all persons associated with this and acting on his behalf colluded with Mr. Shasori and or Ms. Adelori and Mr. Oguini and or individuals, etc., responsible for obtaining evidence for giving instructions to FRN's legal team and or individuals directly and or indirectly involved in FRN's defence to obtain documents and information privileged and or confidential to FRN. Insight this gave to P&ID was a cause of P&ID's continued pursuit of the arbitral claim and or gave P&ID an improper and unfair advantage. Further, or alternatively, P&ID withheld or concealed the fact that it was in possession of and had been was being provided with unlawfully obtained documents and information from FRN and the tribunal. So, importantly, for present purposes, it wasn't alleged that Mr. Andrew had colluded with Mr. Shasori. That allegation had been floated in Nigeria's oral submissions before Sir Ross Cranston, but it was later dropped, and it played no part in Nigeria's pleadings, written or oral submissions. Mr. Justice Robin Knowles, in fact, dismissed most of Nigeria's pleaded case. First, he found that the GSPA was not a sham, was a genuine contract. Can we have up page 187, please, for the call bundle?
Sorry.
And it's paragraphs 489 to 90. 489, the judge finds this. At the point of entering into the GSPA, did P&ID intend, fortunately, to extract large sums of money by means of an arbitration or corrupt settlement? Was the commercial contract from the start simply a device as part of a fraudulent scheme to procure an arbitration award in favour of P&ID? Here I'm satisfied P&ID did intend to perform the GSPA when it entered into it, and there were means by which it could have done so. Secondly, and importantly, he found that Mr. Shasori was not corrupt, and he'd been doing his best to try to win the arbitration. Can we go on to go back to page 178 in this bundle? The judge picks it up from paragraph 442. Neither party called Mr. Shasori as a witness. As far as I'm aware, he hasn't sought independently to provide an account to the court. However, Mr. Shasori has not, in my judgment, been shown to be corrupt. His actions are inconsistent with Nigeria's theory that he was. And the judge then gives 4 examples. I don't think we need to go into the detail, but he reaches the same conclusion in respect of Mr. Chancellor's instructing attorneys, which you find in paragraph 450 on page 180. Insufficient evidence at this trial that they were bribed by P&ID. The evidence shows nothing in the conduct by Ms. Adelori and Mr. Guini of Nigeria's case that casts doubt on the level of honesty of their efforts, while Director of Legal Services to the Ministry and General Counsel to NNPC. Thirdly, and importantly, the judge found that Ms. Nigeria had been deliberately running a false case against Mr. Shisori in order to seek to invalidate the arbitration awards. We get that from 445 of the judgment, page 179. I add that in my view, Nigeria, and specifically Mr. Malami SAN, the Attorney General, did not in truth believe Shisori was corrupt. On 21st November, Mr. Shisori was engaged by Nigeria to represent the Ministry
Sorry,
of Power.
which paragraph are you reading from?
445.
Yeah, okay, thank you.
Thank you. So I'll start again. I added, in my view, Nigeria didn't in truth believe Mr. Shisori was corrupt. On 21st November, Mr. Shisori was engaged by Nigeria to represent the Ministry of Power in a 2.4 billion arbitration claim by Sunrise Power and Transmission Company. His appointment was approved by Mr. Malami San on 6th of March and formally confirmed by Mr. Malami on 18th of March. On 1st of September, Mr. Malami SAN approved the engagement of Mr. Shisori's firm to act for Nigeria in a second arbitration brought by Sunrise, resulting from Nigeria's failure to comply with the settlement agreement. The agreed fee was up to $1.15 million. Mr. Salami Sam has not explained to this court how these events are consistent with the belief on his and Nigeria's part that Mr. Shisori had been corrupt in his professional work for Nigeria in the arbitration. And I note in passing that Nigeria's claim in its skeleton argument in response to this appeal that is driven by a desire to responsibly assist the court of appeal by setting out why the permission to appeal should be refused sits uneasily with the fact that it brought a case of fraud below that it knew to be false. In any case, in spite of these findings against Nigeria, the judge nevertheless set aside the awards, and he did so on the basis of 3 serious irregularities under Section 68 of the Arbitration Act. They're set out in paragraphs 493 to 496 of the judgment. You can find that on page 188 of the core bundle. Heading knowingly false evidence, continued bribery and retention of Nigeria's internal legal documents. There remain three things that bring this case within Section 68(2)(g in my judgment as an irregularity. Each amounted to fraud which the awards were obtained, and by reason of them the awards or the way in which the awards were procured was contrary to public policy. The first is in P&ID's providing to the tribunal, relying on evidence before the tribunal that was material, but was evidence that P&ID knew to be false. Specifically, this was the evidence of Mr. Michael Quinn in his witness statement of 14th of February that was explaining how PA came about. But when he did not do that, because he didn't mention that Mrs. Grace Tiger had been paid a 5,000 bribe at the end of December 2009 and a 5,000 bribe on 29th of March 2010. The second is P&ID's continued bribery or corrupt payment of Mrs. Grace Tiger, directed to the arbitration period in order to suppress from the tribunal and Nigeria the fact that she'd been bribed and the GSPA came about. This continued bribery or corrupt payment is fairly described by Nigeria's bribery to keep her on side and to buy her silence about the earlier bribery. Specifically, these were bribes or corrupt payments on 14th of July, 14th of August and 30th September, totaling $220,000, then equivalent to about $900. A bribe or corrupt payment on 14th September and a bribe or corrupt payment on 14th of June 2016. The third is P&ID's improper retention of Nigeria's internal legal documents that it had received during the arbitration these rather than return them unread, so as to monitor Nigeria's position and awareness as the arbitration continued. This included monitoring whether Nigeria had become aware of the deception being practiced by P&ID on the tribunal and on Nigeria as a party before the tribunal. Specifically, there was a flow of over 40 in Nigeria's internal legal documents to P&ID during the period of the arbitration, from commencement to final award. The detail of the content of a number of the documents is discussed above. All are material, including for the fact they showed to P&ID that Nigeria had no awareness that Mrs. Grace Taiga had been bribed when the GSPA came about, and that the bribery or corrupt payments violence. In essence, so what the judge is finding, that P&ID feared the discovery of bribes paid to Miss Taiga around the time of the original GSPA. They feared that that would undermine their case in the arbitration. So P&ID was held to have devised a scheme to corrupt the arbitration by A, paying bribes to Mrs. Taiga during the arbitration to buy her silence about earlier bribes they'd paid her, and B, obtain privileged documents belonging to Nigeria to keep tabs on whether Nigeria had discovered. Pausing here for a moment, it is striking, we submit, that in this critical part of the judgment, where the judge sets out the irregularities which justify the setting aside of the awards, Mr. Andrews' name is not mentioned at all. Importantly, while Mr. Andrew and P&ID both accepted that Mr. Andrew received some of the documents from P&ID, he played no part in obtaining them, and Mr. Andrews' conduct was not ultimately material to the irregularities which are said to underpin the relief granted by the judge. And all this begs an important question. In circumstances where the judge actually dismissed Nigeria's case against P&ID of collusion, and indeed found that Nigeria had brought its main case dishonestly, on what basis did the judge conclude that Mr. Andrew was corrupt? A reader will look in vain in the judgment for any answer to that question. I will, of course, deal with that in more detail when I can come on to consider ground one of Mr. Andrews' grounds of appeal. Before turning to them, I'd like to first go through the legal framework upon which Mr. Andrews' appeal rests. I'll address 5 main points. First, I'll take you to the decision in Ray W. This established the court's jurisdiction to entertain an appeal by a non-party against findings in a judgment on the basis that there's been a breach of the non-party's convention rights in the way in which those findings have been reached. Secondly, I'll address you on the application of Article 8. I will set out the types of procedural protections which Article 8 imposes, where a judge proposes to make adverse findings against a non-party. Thirdly, I'll analyse the application of Article 6 to the facts of this case and deal with Nigeria's submission that Article 6 is not engaged because Mr. Andrew wasn't a party. Fourthly, I'll go to the requirement for a party to plead its case of fraud, dishonesty or corruption. And fifthly, I'll examine the requirement for a party to put its case of fraud, or dishonesty or corruption properly to a witness. I hope that spending time on these legal principles at the outset will significantly streamline the process of going through the individual grounds of appeal. So the first point is the right...
That fifth point, you go to your point about corruption, can't it? Because to the extent that, that there's a complaint about findings that he was motivated by greed, or that he lied to the judge, and Mr. Howard must have suggested to him dozens and dozens of times that he was lying.
It principally
that he was fencing with counsel in his answers, that he wasn't answering the questions, all the things that traditionally would lead to a judge being entitled to find that somebody had not been telling the truth.
It principally goes to the question of corruption, but not solely, and I'll explain why in due course if I may.
Don't you first have to establish that we have jurisdiction to entertain an application for permission?
Well, Ray W says you do.
what about section 68(4) of the arbitration?
Well, I'm going to come to that at the end, if I may.
Well, it might be said you should deal with that up front, because having reread what I said in the judgment in Manchester City Football Club this morning, it seemed to me you had problems from the outset. But it was all, this was revisited in one of the other, I think, I'm not sure how many appeals there have been in this case. There's certainly been one other appeal to do with the currency of the costs. I think it was to do with the currency of the costs. I don't think anybody here was involved with that.
No.
But I sat with Lord Justice Snowden and Lord Justice Fraser on that, and Lord Justice Snowden delivered the judgment. I think we probably got it in the authorities bundle.
We've got it, yes. And
It cites my judgment in Manchester City.
I don't. We've got the Manchester
suggests
City.
that where something is, as it were, part and parcel of the judge's conclusion in relation to the section 68(4) claim, and it will be said against you that the findings against Mr. Andrew and against Mr. Carhill and so forth were all part and parcel of the judge's, at least one of the judge's reasons for concluding section 68.
Well, we say 68(4) hasn't got any application at all, and plainly not. But I would prefer, if I may, to stick to my current order.
Well,
I will
take
be.
yourself as warned that this court needs quite a lot of satisfying that we've got any jurisdiction at all.
Yes, well, I am duly warned, and I will deal with it in the appropriate
Quite
time.
apart from the fact that the application is out of time, and everything that's said by Mr. Woolen about the tactical reasons for not having brought an application in time, which, if he's right about that, would be another reason why you would not.
Well, we say he's plainly not right about that, but again, I will deal with that at the end, if I may. So I'm going to start with the right of a non-party to appeal against a finding. Mr. Andrews' appeal is unusual because it is brought by a non-party, and secondly because it's brought not against an order of the lower court, but rather against findings in the judgment of the lower court. However, there's a well-established route to bringing an appeal of this nature. Can we turn up the authorities bundle, please, at tab 46, which is the decision of Ray W, and it starts at 1160. And it's common ground between the parties that Ray W does give a route by which parties can appeal adverse findings in judgments if it can be a convention right to breach by the making of these findings. Nevertheless, because there's a point of central importance, it's worth going through the key passages in Ray W in order properly to set out the juridical basis upon which this appeal is being advanced. The proceedings in the lower court in Ray W were care proceedings in respect of children on the basis of allegations that the children had been sexually abused by their siblings. The police officer referred to in the judgment as PO and a social worker referred to as SW had given evidence in these proceedings. The allegations of sexual abuse against the siblings were dismissed, but in his judgment, the judge made a number of findings that PO and SW had subjected the children to a high level of emotional abuse. Those were not pleaded and were extraneous to the in the sense they were irrelevant to the relief granted. Both PO and SW sought to appeal. They were met with two procedural objections. First, that they were not parties. Second, that they were not appealing against an order, but against findings in the judgment. Dealing with, first of all, with the first procedural objection, can we pick it up at 1171? And at paragraph 33, Lord Justice McFarlane cites the George Wimpey decision in which Lord Justice Dyson said this: it would be surprising if the effect of the CPR were that a person affected by a decision could not in any circumstances seek permission to appeal unless he was a party to the proceedings below. Such a rule could work a real injustice, particularly in a case where a person who wasn't a party to the proceedings at first instance, but has a real interest in their outcome, wishes to appeal. The losing party doesn't wish to appeal, and an appeal has a real prospect of success. Over the page at paragraph 36, and then moved on to consider the definition of appellant. He held the meaning of appellant as a person who brings or seeks to bring an appeal wasn't confined to an individual who was a party to the proceedings of the lower court. And then on, turn please to paragraph 41, again over page. The conclusion is, in any event, in the light of the clear ruling by this court, it's my view unnecessary to establish with certainty the precise procedural status of SW and PO in the lower court in order to determine whether or not they may act as appellants in this court. On the interpretation of CPR 52.13d given in the George Wimpey case, it's clear that this court may entertain an appeal from SW and or PO, irrespective of whether they were formally made a party or intervener in the lower court. For completeness, if we can look at 42. Finally, on this point, for reasons I'll describe in due course, if for some reason an individual fails to achieve the status of an appellant, either by a straightforward application of the rules in section 31k, or via the more flexible route of the George Wimpey case, in circumstances where it's established that an individual's rights under Article 8 have been breached by the outcome of the proceedings in the lower court, then this court has a duty under section 3 of the Human Rights Act to read down section 31k and the court rules in such a manner as to afford that individual a right of appeal. So what it shows is a non-party is entitled to appeal because they have an interest in the outcome and because the court will read down the relevant rules to give them the right to appeal if the lower court has breached their convention rights. And we say this is what's happened to Mr. Andrew. The second procedural objection, the appeal lies against orders rather than findings. I think we'll go really straight to the conclusion. There's a discussion of, first of all, the Sia Noga case, where Lord Justice Waller made it clear that the successful party can't appeal a finding he or she doesn't like. And
so where's that?
It starts, I'm sorry, I was trying to go too quickly. It starts at 52,
Yeah,
so page 1175. Where they cite the Sia Noga case. The judgment of Lord Justice Waller was brought on the basis of an order made by a judge prior to the formal document being drawn up and in Ray B. Sorry, I'm lost.
Yeah.
Forgive me. My computer's let me down. I'll be with you in just a second.
Don't worry.
So over page he says, demonstrates the correct reading of Lake and Lake is not that some formal document must exist. Lake and Lake, properly understood, means that if the decision, when properly analysed, and if it would be recorded in a formal order, would be one that the would-be appellant would not be seeking to challenge or vary, then there's no jurisdiction to entertain an appeal. So that's the usual position. But when it comes to a finding that might amount to a breach of convention rights, then the Human Rights Act confers a right to assert those convention rights in an appeal. And we can pick up that analysis at 1191. Just so you know what's been happening between paragraphs 54 and 1110, where we're going to start. In those paragraphs, the Court of Appeal found that the trial judge's findings against the police officer and social worker breached their Article 8 rights to a private life. At paragraph 112, the judge sets out Article 13 of the European Convention. Acknowledged convention right as far as domestic law is concerned, Section 1.1 of the Human Rights Act provides everyone whose rights and freedoms are set forth in this convention are violated shall have an effective remedy before a national authority, notwithstanding that the violation has been committed by persons acting in its official capacity. Then he turns to Section 7 of the Human Rights Act in paragraph 113. The relevant parts of Section 7 are: a person who claims that a public authority has acted or proposes to act in a way which is made unlawful by Section 6.1 may A. bring proceedings against the authority under this Act in the appropriate court or tribunal, or B. rely on the convention right or rights concerned in any legal proceedings, but only if he is or would be a victim of the unlawful act. Subsection 6 in subsection 1b, legal proceedings, includes B, an appeal against the decision of a court or tribunal. Then turning to 114, there's a reference to section 9.1 of the Act. Proceedings under section 7.1a in respect of a judicial act may be brought only by exercising a right of appeal. And then in paragraph 115, pausing there, a court is a public authority for the purposes of section 6 of the 1998 Act. And by section 6.1, it's unlawful for a public authority to act in a way which is incompatible with the convention right. In the present case, I've unfortunately concluded that the High Court has acted in a way which is incompatible, that is, in breach of the convention rights of POSW and the local authority to a fair trial in relation to the adverse findings that were made against them. It is therefore open to the appellants to rely on their assertion that the High Court has acted unlawfully in any legal proceedings which expressly include an appeal against a decision of a court or tribunal, see section 7.6. Indeed, section 9.1 is explicit in providing the proceedings in respect of an assertion that a judicial act is unlawful may only be brought by exercising a right of appeal. So that's the route by which Mr. Andrews seeks to appeal the adverse findings. He maintains that his convention rights have been breached, and he seeks to rely on those.
That, of course, has to be read subject to what the judges, to what Lord Justice McFarlane said earlier in his judgment about just the unusual circumstances in which it arose, which was that the two relevant individuals, there was no pleaded case against them.
No.
It had not been, they'd never been put on notice that the judge might make findings against them, which he did, and so on and so forth. Now, I mean, leaving aside your point about corruption,
Well,
could not be said in the present case, where there was a pleaded case against Mr. Andrew.
but it can be said.
Implicating Mr. Andrew.
Apologies, I didn't
and he
mean
was
to,
cross-examined.
I didn't mean to interrupt you. I do apologise. It can be said about corruption, for sure.
Well,
There's no different. And finding of corruption is a very serious finding. It wasn't alleged, it wasn't pleaded, it wasn't put. And when we get there, one doesn't understand how the judge got there.
well, that again is entirely predicated upon paragraph 592 being a finding against Mr. Andrew.
Yes, of course.
If you're wrong about that, then there is no finding of corruption against him.
Yes. But we're not wrong about that.
I mean, striking that it's nowhere else in the judgment to judge say that Mr. Andrew was corrupt, if it was that important a finding for him to
Well,
make.
when we get there, I say it's blindingly obvious that 592 it relates to Mr. Andrew. You will, of course, make up your own minds about that.
Yeah, sure.
Can I just go to the second legal point, which is Article 8?
Yes.
Let's make some observations about Article 6 and Article 8. I'll start with Article 8, that's set out in the authorities bundle at tab 2, page 37. At the bottom of the page, everyone has a right to respect for his private and family life, his home and his correspondence. There should be no interference by a public authority with the exercise of this right, except such as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being, over the page, of the country, for the prevention of disorder or crime, for the protection of health in moral or for the protection of the rights and freedom of others. So, Article 8 requires one to carry out a two-stage analysis. Was there an interference with a person's right to respect his private life, is the first question. And secondly, if there was, is such an interference in accordance with the law and necessary in the interest of the various legitimate aims identified in Article 8.2. The first question is, was there an interference? It's clear from the authorities that there is a certain threshold of interference with private life that must be obtained. Can we look at the SW in the United Kingdom case? We find that on page 1238 of the authorities bundle. And this rose out of the same underlying facts. W in paragraph 46.
Hang on.
I'm sorry, my lord.
Where?
One, two,
To a tab 49.
tab 49 at 1238.
Yeah.
And we pick it up in paragraph 46 at the bottom of the page. In order for Article 8 to come into play, the attack on personal honour and reputation must attain a certain level of seriousness and must have been carried out in a manner causing prejudice to personal enjoyment of the right to respect for private life. In this regard, the notion of private life doesn't exclude in principle activities of a professional or business nature, since it is in the course of their working lives that the majority of people have a significant opportunity to develop relationships with the outside world. An attack on an individual's reputation, which obstructs his or her ability to pursue a chosen professional activity, may therefore have consequential effects on the enjoyment of the right to respect for his or her private life within the meaning of Article 8. Consequently, the court has accepted the adverse portrayal of an applicant's conduct in an authoritative judicial ruling could, by the way it stigmatised him, have a major impact on his personal and professional situation, as well as his honour and reputation. So it cannot be doubted that the adverse findings have impacted Mr. Andrews' life in precisely the manner envisaged in SW. These are findings made in the context of high-profile litigation involving a sovereign state stating that a reputable solicitor was prepared to use corruption. This language necessarily denotes that he did in fact use corruption, and the trial and his judgment, this was treated as being synonymous with the effects of bribery. This finding, together with the finding that he deliberately misused privileged documents out agreed, has been broadcast all over the media and has tarnished his professional reputation. It has resulted in an investigation by the SRA, will lead to proceedings before the disciplinary tribunal and the real risk of Mr. Andrew being struck off. And Nigeria doesn't dispute that the adverse findings have seriously damaged his professional and personal standing and consequently his right to a private life. Instead, their case appears to be that by giving evidence at trial, Mr. Andrew accepted the risk of having tarnished. And Mr. Nigeria's argument is that Mr. Andrew cannot complain that the foreseeable consequences of his own actions interfered with his right to a private life. And we say we can nip this submission in the bud by considering the authorities on which they rely. The first is the Del Campo in Spain case, which you find in tab 13, page 308. And in that case, the High Court of Justice in Castilla y León found that a local authority didn't do enough to protect a school teacher from harassment by the applicant. In reaching this conclusion, the domestic court also found the applicant had actually harassed the school teacher. The applicant had not been told about the police proceedings. The applicant brought proceedings before the European Court of Human Rights, alleging that the domestic court had breached his Article 6 and 8 rights. Pick it up on page 321 at paragraph 41. Where they say this. The court also reiterates so it's on page 322, I apologise.
322, yeah.
Thank you. The court also reiterates that Article 8 cannot be relied on in order to complain of a loss of reputation, which is a foreseeable consequence of one's actions, such as, for example, the commission of a criminal offence. The court is of the opinion that in the instant case it can reasonably be supposed the applicant could not have foreseen the consequences that the judgment of the High Court of Justice entailed for him. And we've got to miss out about 6 lines and pick it up at the end, 4 lines from the end. The court also lays emphasis on the fact that the applicant was never charged with or proved to have committed any criminal offence. It follows that the disclosure of the applicant's identity in the reasoning of the judgment of the High Court cannot be considered to be a foreseeable consequence of the applicant's own doing. Now, Nigeria relies on this passage as authority for the proposition that a person cannot rely on Article 8 to complain of a loss of reputation which arises from one's own actions. But it's obvious, we say, even on a cursory reading of Del Campo, that the court was simply saying that if you've done something inherently disreputable, like commit a crime, you cannot complain about a loss of reputation if you're charged with that offence and the court gives judgment pronouncing you guilty. But that presumes that we know for certain that you actually committed the disreputable act. In Del Campo, of course, the applicant had never been charged with or proven to have committed any criminal offence.
If it were the case that there was a clear pleading of corruption against your client and the judge had made a finding on that basis, he'd been cross-examined on that basis and the judge had made a finding on that basis, are you saying that he could complain of an infringement of his Article 8
No.
rights in these circumstances?
As long as if it was pleaded and put and the judge gave reasoned finding about it, considering...
The judge's findings that he lied can't really be impugned on this basis, can they?
They can, because it's all about process. There's no appeal on, there's not an appeal on the substance of the findings. My complaints in every single ground of appeal are about process, and I'll explain.
What's the complaint about process here? Mr. Andrews cross-examined for leave corruption to one side for the moment. I follow your point about that. As you rightly say, we're going to have to make our minds up. It's in a relatively narrow compass, that point. But Mr. Andrews cross-examined for 3 days about matters which were pleaded against him, so he must have known they were pleaded against him. We now know that he had, from a relatively early stage, the benefit of advice from Mr. Treverson Jones. He could, in fact, have said to the judge when he received a copy of the draft judgment, well, I really am astonished by you, the fact you want to make these findings against me. I wish to be heard on that. None of that was done.
I'm going to
What's
come
the
to
basis for saying there's been some sort of failure to comply with the process?
I'll come to my grounds of appeal. I really don't want to start arguing my grounds of appeal before I've dealt with the legal points I'm addressing. I will come to it and seek to answer my Lord's concerns.
Well, you're inviting us to look at judgments and to draw certain conclusions from passages and judgments as we go along. So you can anticipate that the court's going to ask you questions about,
of course,
what your case is.
I know the questions are going to come, but if I may, I'll stick to my order, because otherwise I risk getting lost. So, but I accept that if corruption had been pleaded and put, and the judge had given reasoned judgment, then Mr. Andrew could have no complaint. They also rely on, so we say Del Campo doesn't help them. Nigeria also rely on the Legal Aid Board ex parte Kame Todner case. And the proposition that Nigeria seeks to extract from this authority is that parties and witnesses have to accept the embarrassment and damage to their reputation and the possible consequential loss which can be inherent in being involved in litigation. And the suggestion is that as a director of P&ID, by the time the set-aside proceedings were heard, Mr. Andrew has a weak claim to the protection of Article 8, but the Kame Todner case doesn't support such a submission. If that was a case about the making of an anonymity order under Section 11 of the Contempt of Court Act, it involved a firm of solicitors whose legal aid franchise had been terminated following allegations of dishonesty made against them. They sought judicial review of the decision to terminate the franchise and also applied for an order forbidding the disclosure of their identity. So this case had nothing whatsoever to do with with Article 8, or nor any principle of procedural justice. Indeed, the question the Court of Appeal was concerned with was whether on the facts of the case, one could justify departure from the principles of open justice. And we can see the way the Lord Wolf frames the question before the court. Appeal bundle.
Sorry, Mr. Wardell, the line net seems to have stopped operating.
Oh.
About two or 3 minutes ago.
Mine's working.
No, mine isn't.
Mind if I take a look, my lord?
No. By all means, come and I probably pressed something. Have I pressed something? Yeah, okay. All right, thank you.
So we're looking in tab 43, please, and we're going to pick it up on page 1113, which is internal page 977 of G.
So, tab 43.
Tab 43, and it's internal page 977G, please, where you can see Lord Wolf framing the question as follows: any interference with the public nature of court proceedings is therefore to be avoided unless justice requires it. Over the page from 978B onwards, Lord Wolf identifies a number of factors which inform the court's decision as to whether to interfere with the public nature of court proceedings. And paragraph 8 is the key paragraph that the other side rely on, where it's following is said, a distinction can also be made depending on whether what is being sought is anonymity for a plaintiff, a defendant, or a third party. It's not unreasonable to regard a person who initiates the proceedings as having accepted the normal instance of the public nature of court proceedings. If you are a defendant, you may have an interest equal to that of the plaintiff in the outcome of proceedings, but you've not chosen to initiate court proceedings which are normally conducted in public. A witness who has no interest in the proceedings has the strongest claim to be protected by the court if he or she will be prejudiced by publicity, since the courts and parties may depend on their cooperation. In general, however, parties and witnesses have to accept the embarrassment and damage to their reputation and the possible consequential loss which can be inherent in being involved in litigation. So Lord Wolf is saying that some participants in litigation are more vulnerable and have a stronger claim to anonymity than others. The party who initiates proceedings has the weakest claim because they are the ones who initiated and have control. By contrast, defendants and witnesses have their affairs dragged into the public eye made by someone else. So to the extent that this case about anonymity has any relevance to the question of procedural fairness here, it in fact works in Mr. Andrews' favour, because the party in whose support he was giving evidence was the defendant. P&ID didn't instigate the set-aside proceedings. They'd signed up to an arbitration agreement in the belief that any disputes would be dealt with in private, and Mr. Andrew wasn't a party, he was a mere witness. And that's also a convenient point at which to mention another submission which Nigeria have made.
You don't claim he was a witness who has no interest in the proceedings, do you?
No, I can't put it that high.
No, that is what is referred to here.
Yes.
Yeah.
Yes. But we say this case doesn't really have anything to do with
Well,
procedural
the
fair.
proceedings in which he gave evidence and in relation to which the findings have been made against him were in public. The fact that the arbitration was in private is neither here nor there, is it?
Well,
This
but
was
he,
a Section 68 application heard in open court in the commercial court.
yes.
There was no application for it to be heard in
No,
private.
no, sorry, I think we're at cross purposes. If I gave that impression, no, it was my
Yeah.
fault.
But essentially, your client is a barrister and a solicitor, and owns 49% of the shares in the defendant.
Quite so.
So he's not quite the uninterested witness that
No.
Wolf had in mind. And
To the extent to which I gave that impression, I overstated it. Of course I have to accept that. He's not some mere witness. He has a clear financial interest in the outcome of the proceedings.
well, a massive financial interest.
I accept that.
He is himself a lawyer. He had engaged a lawyer, an eminent silk, to act for him in relation to allegations of professional misconduct. And at the end of the hearing, he was given an opportunity to consider the judgment with that leading counsel.
Yes, I'm going to come to Mr.
Very hard to see what was unfair about any of this.
Well, the finding of corruption is unfair. If we're right about 592,
Why didn't he say that to Mr. Justice Knowles when he had the opportunity to do so?
Well, they did.
and they could have clarified.
They did. That was in fact said. It was in the draft grounds of appeal and the skeleton argument in support. Mr. Justice Knowles wasn't prepared to deal with it.
Yes, because you hadn't complied with his order as to how you should deal with it, which was to issue an application.
Yes, but by that stage he was functus. Again, I'm going to deal with that, explain that in due course.
How was he functus?
Because that's what the rules say. Quite clear that after handing down judgment, unless and until the judge extends time for consequential right permission to appeal, the judge is functus. You have to make the application at the hand done. In this case, Mr. Justice Knowles extended time for application for permission to appeal to the consequentials hearing, but he refused to hear Mr. Lee on that occasion and refused to adjourn that application so that an application could be issued. Once that day is over,
Forgive me, maybe I'm misunderstanding something here, but my understanding is your client specifically asked the judge whether he could share the draft judgment
he did.
with his personal silk.
Yes.
And plainly that is in order to consider its impact on him personally.
Yes.
And that surely was the point at which you go and say, forgive me, Judge, but is paragraph 592, it's unclear to whom that is directed. It doesn't specifically name me. Is that an allegation of corruption against me? And if that is against me, it is unreasoned and unexplained, and I'd ask you please to reconsider clarifying that it is not against me. And he didn't avail himself of that opportunity.
Well, he appeared before the judge seeking permission to appeal for the reasons you've just articulated.
But you're saying after handout.
He didn't raise the corruption allegation before the judge.
Did he not? I'm told he didn't raise the corruption allegation before the judge.
Didn't raise such an allegation.
We'll check that.
Well, I think we ought to check it pretty
We will.
quickly, frankly, because I think it is of considerable importance.
Well, if it's helpful, it's supplemental reference bundle D, tab
Supplementary-
115,
Sorry, volume D.
volume D of the supplemental reference bundle, volume 5.
Yeah,
You have the draft grounds of appeal that were put before the judge, which you will see were only 4.
sorry, tab
Page 1225.
1235.
1225.
1225.
And you'll see there were 4 grounds, missing the first ground, which is now pursued before your lordships. And the skeleton, which was put before the judge, is also in the following tab 116, and that finding wasn't addressed.
So all that was addressed was indefensible, which is ground 3.
Sorry to interrupt.
Internal legal documents were privileged, and he knew that. That's before us.
Yes.
And motivated by greed, which is before us.
And ground 4's at the final page 1230. So it's identical. The grounds are almost identical before you, save that what is ground 1 before you did not feature at all before the judge.
So the current ground 1 doesn't feature before the judge.
It only appeared in the appeal to your lordships.
But am I right in understanding that once the draft was handed down, was circulated, but before hand down, there was no attempt to clarify the allegation of corruption?
No, and Mr. Andrew has, I'm sorry, I'll sit down because it's not really my point, but Mr. Andrew has given some evidence about that, but he says he chose not to do so in light of something the judge had said.
It's not quite right to say that the corruption point wasn't raised. If you look at page 1228, please. Paragraphs 10 and 11. 592 is there quoted, and it's said at 11 it's understood that 592 is intended in part as a critical reference to the conduct of Mr. Andrew. Now, if I can go back to what is being said about Mr. Andrew's alleged control over the proceedings,
I haven't really followed exactly what did happen procedurally. It all seems to be slightly odd. These grounds of appeal were put before the judge when?
They were sent, I think, either the night before, possibly the Wednesday of that week. I can't. And there was
6th of December.
Yeah, it was sent. The grounds of appeal was sent on the 6th, together with the skeleton argument. The intention was to invite the judge to give permission to appeal on that day.
And that was
the 8th of December. By the time Mr. Lee gets there to make the application on behalf of Mr. Andrew, it's clear that the agenda is very full. So Mr. Lee invited the judge effectively to extend time for seeking permission so that the application could be made in the way the judge had in mind by issuing an application notice. But the judge didn't extend time and said that if the process is to start, I need an application notice. And by that stage, the judge couldn't seek an application notice without giving an extension of time because he's functus. And the law's absolutely plain about that. Yes. And I'll come back to Mr. Treverton Jones' point at the moment, but Mr. Andrew does explain in paragraph 15 of his 11th witness statement that the judge discouraged an application from being made. And perhaps we ought to have a quick look at that. It's the core supplementary bundle at page 49.
Does the skeleton argument address this failure to the corruption point? It addresses the greed point.
I will
Failure to
get
put
someone
case
behind me
to
to look at the, I'll get someone behind me to remind themselves of the details of the skeleton argument that was before him. Well,
you signed it.
I did, but that was December.
I know it's December 23, but you know, and this has taken an unconscionable length of time to get before this court. But sorry, where are you going now?
Hey, core bundle, Mr. Andrews' 11th witness statement. It's
Core bundle.
It's core supplementary bundle. It's page 249.
Core supplementary bundle, page 249.
It's page 49. I apologise.
Sorry.
Misheard. 49. It's paragraph 15.
Hang on. I'm now completely lost as to where we are.
We're in the core supplementary bundle, page 49, paragraph.
Page 49.
Yeah, paragraph 15.
Okay.
So he explains that he wrote to the judge on the 17th of October to seek permission to speak to Mr. Treverton Jones, which was granted the following day. Although I was granted permission to show the judgment to Mr. Treverton Jones, the judge also stated this is not, however, to be taken as any indication that an application on behalf of Mr. Andrew in relation to the confidential draft judgment would be appropriate. In light of the terms of the judge's response, I refrained from making any formal application at that time and instead sought specialist advice about an appeal as a non-party.
Isn't that just a neutral observation of the judge at that stage?
Yeah.
Well, I'd say
Well, you see, it's exactly what it is, with respect, Mr. Wardell. It's somebody who wasn't a party
well,
asks for permission to show the draft judgment as to his own lawyer in the present circumstances. What the judge says seems to me to be entirely, as my lord put it, neutral. And what would one would expect?
well, I
The
think
idea that somehow it was regarded as shutting him out from making an application seems to me to be misconceived.
well, it's not shutting him out. It was regarded by him as a discouraging observation. But I'm not going to press that point.
No.
May I just understand the timing, so that this was on circulation of the draft that Mr. Andrew wrote to the judge,
Yes,
but the consequentials hearing didn't take place until
December.
December.
And time it had been extended for permission to appeal till December.
So what Mr. Andrew says here is, I refrain from making any formal application at that time, that is the 17th of October,
Yes,
and instead sought specialist advice about appeal as a non-party.
yes,
But he had until December to do that.
yes, and he did that. The grounds for appeal and supporting skeleton were put before the judge. So I was just going to
By that stage, the judgment had been handed down, hadn't it? The 23rd of
October.
October.
Yes. So I was just going to make a few observations about Mr. Andrews' control over the proceedings. He's set the record straight in his 12th witness statement, to which the other side object, but I would ask you to look at it on a De Bene essay.
Where's that?
You'll find that at the supplementary reference bundle, tab 10, page 154.
154.
We can pick it up at paragraph 10 on page 156, where he says the 3-day jury directors of P&ID were myself, Emile Dutoit, and Jeffrey Johnson. Mr. Dutoit and Mr. Johnson were employees in the VR Capital Group. Neither of them had any role in the running of the litigation. I understood Mr. Dutoit and Mr. Johnson to be nominees for VR Capital. March 10, paragraph 11, this is, state that the directors delegated authority to give instructions to legal counsel with respect to these proceedings to a number of named individuals, including me. However, no such authority was ever conferred on me. Initially, Cobra and Kim were P&ID solicitors of record. The Cobra and Kim engagement letter provided they could rely on instructions from any of Richard Dites, Sina Tusi and Josh Nemza, all of whom were VR Capital personnel, without the need for approval from any other representatives of the client. A further engagement letter dated 12th of September provided that Cobra and Kim were entitled to act and rely upon instructions from any of the following, as if such instructions had been given by P&ID. That's Nick Mast, Ted Greeno, Marina Botarashvili of Quinn and Manuel, and Joshua Nemza, Martin Moses, Steve Penner, and Richard Dice was not among the named individuals in either of these engagement letters. Copies of the Cobra Kim engagement letters are exhibited, redacted save as to relevant non-privileged parts. And Quinn and Manuel replaced Cobra and Kim in September 22, and their engagement letter says they're entitled to take instructions from any two of the following individuals. And at that instance, Mr. Andrew is named. And he goes on to say in paragraph 13, given the Messrs. Dykes, Nemser and Moses were VR Capital people, I didn't regard my position in relation to Quinn and Manuel as materially different to my position in relation to Cobra and Kim. In both cases, VR Capital retained control of what instructions were given to P&ID's legal team. In neither case did I have authority to instruct without the backing of VR Capital, and in both cases, VR Capital had the right to instruct without my consent. And secondly, I'll come back to this later, the fact that Mr. Andrew had no control over the proceedings is borne out by the fact that P&ID effectively abandoned his defence about his treatment of the documents. That's something I'll address when I get to ground 2. So there are my submissions on the first limb of the Article 8 test. The adverse findings are clearly an interference with his right to private life. It cannot be said that by the mere fact of him giving evidence, he surrendered his right to freedom from interference with his private life. And then the next question in stage 2 is what procedural protections was he entitled to? It's common ground that Article 8 imposes a duty on public authorities to ensure the proper procedural protections are put in place to safeguard article rights. The point is articulated in plenty of authorities, but the most convenient for our purposes is the R and Staffordshire and West Midlands Arbitration Trust case, which you'll find in the authorities bundle at tab 41, page 10, starting at 1062. And we can pick it up on page, and this was one of the decisions cited with approval by the Court of Appeal in Ray W. Can we pick it up at paragraph 58 on page 1080, please? Paragraph 58, Mr. Justice Cranston observes in the context of Article 8, what the Strasbourg Court requires is that the decision-making process involved in measures of interference, when considered as a whole, must be fair, and such as to afford due respect to the interests safeguarded by Article 8. And at paragraph 60, he describes what is required by way of procedure as follows. What is required by way of procedure in any particular case turns on the extent of interference with those rights and the nature of the interests at stake. That is the same approach as the common law. The standards of fairness are not immutable. So there's no hard and fast rule as to what procedural protections are required by Article 8. It varies on a case-by-case basis, but he goes on at paragraph 60 to describe two procedural rules which are essentially inevitable if one is to preside over a fair process. And we can pick it up where he says fairness. So it's halfway down 60. Fairness, he said, very often required that a person adversely affected by a decision have an opportunity to make representations on his own behalf, either before the decision is taken with a view to producing a favourable result, or after it's taken with a view to procuring its modification, or both. Lord Mustill added that since the person affected usually cannot make worthwhile representations without knowing what factors may weigh against his interests, fairness very often required that a person be informed of the gist of the case to be answered. So two basic elements of procedural fairness. The person must have notice of the matters which might be held against him, and that must mean that those matters must be pleaded and properly put to him. And the second element of procedural fairness is not enough for the person to have notice of the allegation. You must have an opportunity of dealing with it. And that may well entail giving the party the opportunity to seek independent legal advice, the point that's made in Ray W, a passage I haven't taken you to, but for your note, it's paragraph 95, Appeal Bundle, tab 46, page 1187. And so we say it cannot be seriously in dispute that it was necessary for the case against Mr. Andrew to be both pleaded and put to him. And I'll come to precisely what we say on each ground of appeal when I get there. But whilst on Article 8, we say there's a third element of procedural fairness, which isn't mentioned in Tabak, but which is of great importance in this particular appeal. That is that a judge must give adequate reasons for his conclusions. Can we turn to the Lord Justice Mayles' judgment in Symmetra, which you find in Appeal Bundle, tab 58, starting at 1201, but we'll pick it up at 1209.
Sorry.
It's Appeal Bundle, tab 48, might be tab 58.
48.
48, thank you.
Symmetra.
Thank you, 1209. And I was going to pick it up in the judgment of Lord Justice Mayles, 5 lines in, where he says, second, it's not necessary to deal expressly with every point, but a judge must say enough to show that care has been taken and that the evidence as a whole has been properly considered. Which points need to be dealt with and which can be omitted itself requires an exercise of judgment. Third, the best way to demonstrate the exercise of the necessary care is to make use of the building blocks of the reasoned judicial process by identifying the issues which need to be decided, marshalling, however briefly and without needing to recite every point, the evidence which bears on those issues and giving reasons why the principally relevant evidence is either accepted or rejected as unreliable. Fourth, and in particular, fairness requires that a judge should deal with apparently compelling evidence where it exists, which is contrary to the conclusion which he proposes to reach, and explain why he does not accept it. Can I just ask, are my Lord's screen still working? Because mine's gone.
I do not have the authorities. Can you repeat what bundle that was, please?
It's the authorities bundle.
Authorities. Apologies.
Thank you. So we say this is an important passage. We accept that the extent of the reasons required will differ from case to case. And we're not suggesting that the judge necessarily had to offer extensive detailed reasons for making the adverse findings, or that he had to address every single piece of evidence relating to Mr. Andrews' conduct. But there is a basic threshold of care that is required. The trial judge needed to show that the evidence as a whole had been considered and had to deal with apparent compelling contrary evidence. It would be plainly a breach of the obligation to give reasons for a judge either to give no reasons at all or fail to engage with any of the evidence to the contrary. And as I'll come on in due course, that is what we say the judge did in this case. This is a convenient point to address an argument which Nigeria has made in its skeleton. You don't need to look it up. But namely that Article 8 doesn't import a duty to give reasons. They say that this is a procedural protection which arises only under Article 6, because only parties have rights to reasons. An immediate problem with this submission is that Article 6 also applies to non-parties. I'll develop this point in more detail when I look at the authorities in Article 6. But if I'm right, then there is no real reason why the procedural protections under Article 6 should differ from those available under Article 8. But I also want to look at this point on its merits and explain why Article 8 does require a court to give reasons if it makes adverse findings against witnesses. Now, I accept that the authorities on a duty to give reasons relate only to parties. But that's not surprising because non-party appeals are, by their very nature, very rare. And of course, there's no authority which says that witnesses do not have a right to reasons. And we submit that given the lack of any conclusive authorities on the point, the court must approach this from first principles. We know from Tabat that the procedural protections required by Article 8 depend on the circumstances. And there are compelling reasons why Article 8 plainly does require judges to give reasons as and when they make findings which are damaging to a non-party's reputation, prima facie interferes with his Article 8 rights. The first reason is that a witness must be left in no doubt as to why adverse findings have been made against him. Can we go back to Symmetra and pick it up at page 1207?
Yeah.
And this is citing the judgment from Flannery at 30, under the paragraph 39, and just remind you of what Lord Justice Henry said in Flannery. We make the following general comments. The duty is a function of due process and therefore of justice. Its rationale has two principal aspects. The first is that fairness surely requires that the parties, especially the losing parties, should be left in no doubt why they've won or lost. This is especially so since without reasons the losing party will not know whether the court has misdirected itself and thus whether he may have an available appeal on the substance of the case. The second is the requirement to give reasons concentrates the mind. If it's fulfilled, the resulting decision is much more likely to be soundly based on the evidence than if it is not. Now, of course, Lord Justice Henry was talking about parties, knowing whether they have an extant right of appeal. But non-parties, as we've seen, can appeal on the grounds of an interference with their convention rights. And if a judge doesn't explain the reasons for their conclusions, it becomes impossible for a person to tell if the interference with their rights was justified by relevant and sufficient reasons. And some support for this can be found back in the Del Campo case, if we can go to tab 13, page 323. And we pick it up at 49 of Del Campo, where the court says the court's therefore of the opinion that the disclosure of the applicant's full name in the High Court of Justice's judgment, coupled with the statement of his acts as part of its own reasoning, was not supported by any cogent reasons. And that was, of course, an uncontroversial finding. An interference with one's rights cannot be justifiable if the public authority cannot even set out the reasons which are said to justify the interference. And if we go back to Flannery as set out in Sumatra at page 1207, back to tab 48. I've already taken you to that passage. So one of the principal rationales of giving the requirement to give reasons and to satisfy the requirements of due process is that it concentrates the mind. And this is a case where the judge clearly intended to make a finding which caused serious damage to Mr. Andrews' life and reputation. And we say the law would be defective if it didn't insist that the judge's mind be focused on what Lord Justice Mayles said or referred to as the building blocks of the reasoned judicial process. Ultimately, this all comes down to a question of fairness. Whether one is considering Article 8, Article 6, Article 8 or the common law, the lodestar is to ask whether the procedure put in place was fair to the person whose rights were infringed. Can we look also at paragraph 34 of Popely and Aiton?
This was Sumatra, for example, which you've taken us to, was a case in which, unfortunately it happens to have been the same judge, but it was a case where it was a 13-day hearing where the judge had produced a 13-page judgment. It was quite notorious at the time, frankly.
Yes.
And he simply hadn't dealt with a number of the issues. In the present case, leaving aside your point about corruption, if one takes, for example, the judge's findings at paragraph 214 to 216 of the judgment about your client and his evidence, I'm struggling to see what other reasons the judge was obliged to give, frankly.
Well, let's look at the document. The question is, before deciding
A
whether...
solicitor who's, frankly, Mr. Wardell, a solicitor who knows that his client has privileged documents of the other party which have come to the client, not through the other party having, as it were, deliberately disclosed them and waived privilege, but a solicitor who knows that they've come by a nefarious means, which is what the judge has found. The idea that not returning the documents, or at least telling Nigeria that they've got the documents so they can make an application for their return, the judge had to spell out why that was indefensible.
Yes, he did, because
it seems to me to be fanciful, frankly.
Absolutely did, because there is no, we say on the authority, on the Court of Appeal authority, there is no obligation to return the documents at that stage. And the question of whether or not Mr. Andrews' conduct was defensible or not has to be assessed by, first of all, looking what the duty is to return. Is there a duty? And I'm going to take you to White and Withers and the Chenguis judgment in due course. And secondly, what the solicitor knew or thought his duties were before one can begin to assess the extent to which his or her conduct was defensible. Now, the judge failed to engage with that at all.
Yes, because the judge didn't believe your client's evidence. And
No.
hadn't appreciated what the
He
documents said.
No, he failed to engage with the question of what the solicitor's duties were. That was a necessary first step before he has any justification for finding that a failure to return is indefensible.
Well, just assume, for the purposes of the argument, that the judge was right, that your client appreciated that his client had the other side's privileged documents by means that they shouldn't have had. In other words, they hadn't been disclosed by the other side as part of some settlement or something of that kind. They'd been obtained by nefarious means. What do you say your client's professional obligation in those circumstances was?
Not to deploy them, under no obligation to return them, and because he's got conflicting duties of confidentiality to his client. And that was raised.
What if his client, I mean, what I would have expected your answer to be is that at the very least he should be to do is to tell his client that they shouldn't have the documents and that he couldn't continue to act for them if they continue to deploy them.
Well, it's not as straightforward as that, as you'll find in due course, because some privileged documents were sent direct to Mr. Andrew, clearly via a waiver of privilege route. So it's not nearly as straightforward as you're suggesting, but can I come back to that? I was going to take you to Popely at tab 38, page 1015 of the authorities bundle. Still dealing with Article 8 on fairness. I'm just going to draw to your attention.
38.
Yes. Just going to draw to your attention paragraph 34. Where it said that, importantly, Article 8 private life rights include procedural rights to fair process in addition to the protection of substantive rights. Thus, in Zurich and Slovakia, the European Court said that whilst Article 8 of the Convention contains no explicit procedural requirements, the decision-making process involved in measures of interference must be fair and such as to ensure due respect of the interests safeguarded by Article 8. And we say that basic fairness in the case of a witness being found to have been corrupt, if we're right about that, must surely entail giving reasons for that finding, which is devastating to his reputation and personal life. And while we've got Popely open, can we go on to paragraph 53 at the top of page 1021?
Yeah.
1021, she says, line 2, I consider the adverse findings must be viewed as a whole. Taken together, they add up to a complete narrative, which is both extremely serious and clearly capable of engaging Article 8 and Article 6 rights, together with the entitlement to common law protections. And those three rights, Article 6, Article 8 and common law, are effectively treated as being coterminous with each other, and that must be right. Because whether you're looking at the articles or the common law, the question is very simple. Considered as a whole, what is fair and what accords due respect to the interest being safeguarded? And to approach it any other way would lead to the bizarre conclusion that the European Convention of Human Rights conferred weaker procedural protections than the English common law. I can just refer to two authorities, which I'll just give you the reference number. We know that procedural unfairness is a basis of judicial review, and we know that judicial review can be sought against certain judicial bodies. And in the case of MR8 solicitors, which you'll find as an example at tab 35 of the authorities bundle, in that case, a non-party successfully sought judicial review against Manchester County Court for having made findings against it which were unpleaded and never put. And then we know the Mahan and Air New Zealand case, that one can seek judicial review against the findings made against a witness in the public inquiry. I don't need to take the decision itself, but the relevant passages are in the head note at Authorities Bundle 33, page 897, and its internal pages 820F to 821C on pages 908 to 9. And in the Mahan case, Captain Gemmell was one of the parties seeking judicial review, even though he wasn't a party to the inquiry. The Privy Council found that the rules of natural justice required the presiding judge to ensure that any person at risk of an adverse finding, including the captain, was given an opportunity to respond to those findings and had a right to adequate reasons which were not self-contradictory. And in each of those routes, each of these cases, the route to challenging the unfair findings by way of judicial review, by asserting their common law rights. But what if the solicitors in MRH or had decided to assert their convention rights instead and proceeded by way of the route opened up by Ray W., we say it cannot seriously be suggested the result on judicial review should somehow differ from the result on a non-party appeal. And we say this for this reason, my learned friend's objections about the scope of Article 8 and the duty to give reasons fall flat. True it is that all the key authorities about the duty to give reasons about common law rights, but what the common law requires by way of fairness cannot materially differ from what the European Convention requires. And it is surely a basic aspect of fairness that a person is entitled to reasons for a decision which has destroyed his professional life. So standing back, we say that Article 8.2 imposes process requirements, and there are three critical process requirements which apply here. An obligation to give a non-party witness notice the allegations against him. Secondly, an obligation to ensure that the non-party can address those allegations. And thirdly, an obligation to give reasons for any adverse finding. Now I turn to my third legal point, which is the law on Article 6. I need to do so because my learned friends have submitted that Mr. Andrew has no right to rely on Article 6. Can I ask you to turn up the fired case at Authorities Bundle 16, page 367. And we can pick it up on page 399 at paragraph 54. And there they set out Article 6. In the determination of civil rights and obligations, everyone is entitled to a fair and public hearing by an independent and impartial tribunal established by law. And Article 6 only applies if there's been a determination, which you get from paragraph 56. And what civil right does Andrew say was determined by the trial judge? And that we pick up at paragraph 58 over the page. And in regard to the cases of Golder and the United Kingdom and Helmans of Sweden, the respondent government did not dispute the existence and civil character of the right under law, English law, to a good reputation. And the proposition that there is a civil right to reputation, the determination of which is protected by Article 6, is well established in the Strasbourg and English jurisprudence. And it's that right which Mr. Andrews submits has been determined by the making of the adverse findings. And the question which follows is, what does it mean to determine a civil right? Can I ask you to go back to paragraph 56, where it says, in order for an individual to be entitled to a hearing before a tribunal, there must exist a dispute over one of his or her civil rights or obligations. It follows, so the court's case law is explained.
Sorry, where are we?
Paragraph 56 on page 399. Starting in order for an individual.
Livenet has crashed again.
Can I keep going, or would you prefer me to wait?
Just wait a moment, please. You better get somebody to look at this at lunchtime, please.
Is it working now?
Okay, let's try. Not sure. Doesn't seem to be working still.
So I was taking you to paragraph 56.
No, it does. Okay, yeah. Sorry, paragraph 56.
56 on page 399.
Yeah.
In order for an individual to be entitled to a hearing before a tribunal, there must exist a dispute over one of his or her civil rights or obligations. It follows, so the court's case law has explained, that the result of the proceedings in question must be directly decisive for such a right or obligation, mere tenuous connections or remote consequences not being sufficient to bring Article 6(1) into play. Put another way, we said that determination in Article 6 means decision. What Article 6 requires is for the public authority to make a decision which directly interferes with a person's civil rights. That entails that the public authority is in a decision-making role, and the reason why the application in Fide was unsuccessful was because there was no decision by a public authority. All that happened was a report by investigators who had been appointed to carry out an investigation to the acquisition of the House of Fraser. For the ratio, you can find that for your note at paragraph 61. I wasn't going to take you to it. What you'll see from that paragraph is that the court draws a distinction between a public authority that merely investigates and a public authority that has a decision-making remit. The actions of a body without decision-making authority, like the inspectors in Fide, will not engage Article 6, but by contrast, the actions of a tribunal, court or panel convened to make decisions will in principle engage the article, if their decisions determine and affect a party's civil rights and obligations. By contrast, where the public authority sits in a decision-making capacity, the question whether civil right is determined is not constrained by the forms of civil procedure. It's a question to be determined as a matter of substance and shouldn't be construed in a formal or technical way. And if we can go to the Perez in France case, tab 36 of the authorities bundle, we can pick it up at 983. And at paragraph 64 on 983, the government also considers it necessary to establish that a contestation doesn't begin until a claim for compensation has been lodged. In this respect, the court notes that the right to fair trial holds so prominent a place in a democratic society that there can be no justification for interpreting Article 6.1 restrictively. Conformity with the spirit of the Convention requires that the word contestation should not be construed too technically, and that it should be given a substantive rather than a formal meaning. Besides, it has no counterpart in the English text of 6.1. Moreover, if the making of a civil party complaint amounts to the same thing as making a civil claim for indemnification, it's immaterial that the victim may have failed to lodge a formal claim for compensation. By acquiring the status of civil parties, victims demonstrate the importance they attach not only to the criminal conviction of the offender, but also to securing financial reparation. In any event, it's conceivable that Article 6 may be applicable even in the absence of a claim for financial reparation. It suffices if the outcome of the proceedings is decisive for the civil rights in question. And drawing these threads together, Mr. Andrews submits that his civil right to reputation has clearly been determined by the judge below. The judge sat in a decision-making capacity. The judge decided that Mr. Andrews did not warrant his good reputation because he was corrupt, and in publishing those findings in a public judgment, the judge has destroyed Mr. Andrews' good name. Now, as I said at the outset, Nigeria has submitted that Article 6 doesn't provide non-parties, such as Mr. Andrews, with procedural rights. They don't really develop this in their written submission, so I may have to come back to it and reply. But for now, I submit the authorities are clear that the application of Article 6 doesn't depend on whether you're a party. In this regard, there are 4 relevant cases which I draw your attention to. The first is SW in United Kingdom, which you find tab 49, page 1245. We've already looked at this on a different point. Can I just draw your attention to paragraph 78? The court has stressed that the question of the applicability of Article 6 cannot depend on the recognition of the formal status of party by national law. They rely on the Arnoldi case, which I'll deal with shortly. You'll find it tab 7, page 135. The case is about the applicant was involved in civil proceedings and was opposing the construction of a chimney on her property. She thought that the witness statements that had been filed had been forged, so she issued a criminal complaint. And under Italian law, she couldn't become a party to the criminal proceedings until a preliminary investigation was concluded. That investigation took 7 years and never finished. at that time if she was told that her complaint was time barred. So she'd never become a party. And the Italian authorities responded by saying Article 6 only protects parties and she wasn't yet a party. But the court nevertheless found that her civil rights had been determined. And we can look at page 135, at the bottom of that page. The last two lines, by lodging a criminal complaint and as detailed at point 2 below, applicant had demonstrated her interest in obtaining redress in due course for the breach of a civil right to which she could claim entitlement on arguable grounds. And three paragraphs further down, under Italian law, the position of an injured party who, while awaiting the opportunity to join the proceedings as a civil party, had exercised at least one of these rights and opportunities in the criminal proceedings, was not substantially different from that of a civil party. The outcome of the preliminary investigation was thus decisive for the civil right in question. So Arnold clearly establishes, we say, that Article 6 rights apply irrespective of whether someone is a party to proceedings. Indeed, it just shows how widely Article 6 applies. It was held that it could apply even to criminal proceedings brought in support of a separate civil claim. And that must be a right as a matter of principle. And the purpose of Article 6 is to ensure that decision makers make decisions, that when decision makers make decisions which interfere with Article 6 rights, they do so in a fair and impartial manner. And what both SW and Arnoldy say is not just the rights of parties that are vulnerable in this way, non-parties can also have their rights determined. We say non-parties are in some respects more vulnerable than parties because they don't control the course of litigation, they don't decide whether or not to bring claims, and they don't control what questions are asked of them or how the litigation should be managed. And the two other authorities I draw to your attention, first is Jane and Trent Strategic Health Authority. That's the Authorities Bundle 28, page 780. And the second is Queen and Secretary of State for Health, Appeal Authorities Bundle 421085. In both cases concern findings and orders made which were made ex parte. And that didn't prevent the applicants making claims. And in both cases, the House of Lords was clear that the claimants had Article 6 rights that had been breached. But in neither case was the claimant a party to the application in the real sense because they were never heard. So that's one of the. So we say Article 6 does extend to non-parties, and Mr. Andrew has clearly had his Article 6 rights interfered with, and therefore the question arises as whether or not that has been done fairly or not. Mm-hmm. Fourth legal point is a requirement for a party to plead your case. This, I hope I can dealt very shortly. It's trite that if one's going to make allegations of corruption or dishonesty, it must be pleaded as well as put.
I don't think we need any help on that.
Thank you. And I was just going to take you to one passage, if I may. It's the Vogon case, Authorities Bundle 51, page 1542. Paragraph 34. Authority.
34.
Vogon. It's paragraph 34, I think.
No, there are only 33 paragraphs in that case.
Oh, it's 24, sorry. Yes, 29, I'm sorry, I was looking at the wrong authority. I also consider the judge was entirely wrong in the circumstances of this case to make these unnecessary findings. I regret to say, elementary common fairness, neither parties to litigation, nor their counsel nor judges should make serious imputations or findings in any litigation when the person against whom such imputations or findings are made have not been given a proper opportunity of dealing with the imputations and defending themselves. So moving on, the last point is, again, I hope I don't need to trouble you with this, is the requirement for a party to put its case to a witness.
Yeah.
And we obviously rely on...
We don't need much help on that either, Mr. Wardell.
No.
If you were right on what you submit in relation to corruption, then it wasn't put, you say.
Yes. So I think, just so you'll know, in case we get there, on the obligation to put one's case, we rely on the Griffiths and Tuohy case.
Yeah, Griffiths and Tuohy is, you know,
Yeah.
you locus classicus now.
Exactly. So, ground one. Ground one, you know, relates to paragraph 592. And we say that contains a damning indictment of at least Mr. Andrew and Mr. Burke. Ground one is about the finding that Mr. Andrew was prepared to use corruption. The first question is, was there such a finding? Because Nigeria submits that this is not actually a finding about Mr. Andrew at all. Rather than their skeleton argument, they argue that this is just an endnote which doesn't identify any specific individual. Now that's quite a U-turn for Nigeria. Can we look at their statement of objection, which you find in the call bundle? In relation to that statement of objection to Andrew's application for permission to appeal, that's call bundle at 253.
253.
In the middle of paragraph 9,
Hang on.
they say ground one is taken out of context with the judge amply entitled to identify that Mr. Andrew was prepared to use corruption in the light of the judge's explicit findings as to his involvement in the receipt of documents. We say there's no doubt that the judge was referring to Mr. Andrew. If we can go back to the judgment at tab 4 of the call bundle at page 208. We've already looked at 592. The judge immediately goes on, 593. I'll be referring a copy of this judgment to the Bar Standards Board in the case of Mr. Trevor Burke and to both the Solicitors Regulation Authority and the Bar Standards Board in the case of Mr. Seamus Andrew. I trust that these two regulators of the legal profession will consider the professional consequences of the conduct of Mr. Burke and Mr. Andrew in relation to Nigeria's internal legal documents. As a separate matter, although there was argument before me about the acceptability of the remuneration arrangements of Mr. Burke, that would be a satellite point for these issues. I have the responsibility to decide, and it's best left for the regulator for whom it will be a central point. And reading down to 594, the page, against the deeply unhappy matters to which I referred in the last two paragraphs. The judge clearly intended that paragraphs 592 and 593 should be read together. And this is how 592 has been understood by the world at large. Can I ask you to turn up call bundle 4208, please?
We've got it. 592s.
Sorry, it's call supplementary bundle 40.
Call supplementary bundle
40.
Page 40.
Page 40. And we can pick it up. And this is Mr. Andrews' 10th witness statement. Anyway, he deals with the impact of the judgment, and he quotes some articles in Reuters, Bloomberg and the Times, all of which were refer to, well, certainly the Reuters judgment, if you go over the page, refers to the prepared to use corruption. At 513 over page. Showed what some people would do for money driven by greed and prepared to use corruption, giving no thought to others. Then we have Bloomberg reporting on the two lawyers. And at 522, they quote from the case highlights what some individuals will do for money. The judge said driven by greed and prepared to use corruption, giving no thought to what their enrichment would mean in terms of harm for others. And in the Times,
Yeah.
pick it up over page 532. In an endnote stating he'd be referring the lawyers to their professional regulators, Knowles said that the case showed what some people do for money when they're driven by greed and prepared to use corruption. So that's a clear understanding that the prepared to use corruption related to Mr. Andrew. And it's not just the media, it's that Nigeria's own legal team, both solicitors and counsel, regarded the prepared to use corruption as referring to Mr. Andrew. Now, can we look at the unagreed documents bundle? Again, I'd ask you to look at this De Beni essay. We find it in the unagreed documents bundle at page 12, page 2 to start with.
Can I just say, there are some classified documents in here. Is it okay to display them?
Yes, because I'm asking the court to look at this De Beni essay.
Unagreed documents bundle.
Unagreed documents bundle.
Right.
And this is the Mishcon de Rare.
Is there any objection to our looking at this, Mr. Wade?
No, well, we didn't agree with them going in because we think it's wholly inappropriate to be looking at press releases and councils' websites and things. But if your lordships want to look at them, De Benes, I have no objection to you doing so.
Okay, which one do you want us to look at?
First on page 2, there's a paragraph half down the page starting Mr. Justice Knowles' decision, follows the highly anticipated 8-week trial.
Yeah.
And it's the last two lines of that, or 3 lines. The court also heard the explanations given in cross-examination by 7 of P&ID's factual witnesses, included by P&ID's sole survivor co-founder and 2 English lawyers, Trevor Burke and Seamus Andrew, both of whom were found to be central to P&ID's fraudulent operation. And then just a couple of extracts from the Brick Court podcast from Mr. Howard, which you can pick up on page 16 of the bundle. Halfway down the page, you've got a sentence starting Quinn's nephew. He was in it for a share of the action, as was Mr. Seamus Andrew. When I say a share of the action, by the time of the trial, the award was worth something of the order of 11 billion. They were in for somewhere between them of 1 billion to 3 billion. Nice work, you can get it. So they were part of the corrupt scheme. And they go on to now, next paragraph, now they were pretty brazen and they did turn up to give evidence. We had evidence from Cahill, from Burt, from Andrew. Now Cahill and the other P&ID witnesses essentially thought they could brush aside their history of corruption, and over the page at 17, I don't think we need to go to that. So we say it is important how the world reacted, how the world has interpreted this judgment. If everyone thinks that 592 refers to Mr. Andrew, as we say it clearly does, then that engages his convention rights. And it's completely unrealistic for my learned friends to come along to this court and say to this court, well, if you look at it carefully, or you look at our change of attitude to this judgment, Mr. Andrew hasn't really been found liable, guilty for corruption at all. They have another string to their bow in their skeleton argument. We don't need to look it up. They say that 592 is just limited to findings about Mr. Andrew's handling of the internal legal documents. But as a matter of language, that doesn't work. Merely handling documents, merely handling privileged documents, I should say, even if those obtained illicitly, is not corruption in any meaningful sense of the term. It's only in corruption if Mr. Andrew himself was corrupted or procured these documents by corrupting others. And of course, there was no finding that Mr. Andrew either gave or received bribes. The judge accepted that some of the documents had been shared for legitimate reasons, and one of them, that I'll come to later, was openly sent by Mr. Shasori's firm to P&ID's agent, Mr. Adebayo. Moreover, when read in context, the only way to make sense of the term corruption in 592 is to refer to the wider corrupt scheme which P&ID was found to have perpetrated. I've already shown you paragraphs 4, 9, 5 and 6. Can we just put them up just to remind ourselves of them in the core bundle of 188? And 4, 9, 5 and 6 is the scheme. I took you to those passages at the outset, and they set out what the judge considered the corrupt scheme to be, namely to cover up its history of bribery by paying further bribes to Miss Tiger, and then procuring the internal documents to monitor Nigeria's awareness of the bribes. That's the sense in which the judge refers to corruption generally throughout the judgment, namely a scheme of bribes and collusion with Nigerian officials. When he says that Mr. Andrew is prepared to use corruption, he must be saying, to make any sense of it, that Mr. Andrew knowingly participated in the corrupt scheme to bribe and monitor. In an attempt to square the circle, Nigeria have now sought to reinterpret the phrase prepared to use corruption to mean that the arbitral process was undoubtedly corrupted by Mr. Andrew's receipt, retention and use of the FRN internal documents. But that's not what the judge said. He's saying that Mr. Andrew knowingly participated in a corrupt scheme. That allegation was never pleaded, never put, and is unsupported by any reasons at all.
Can I just ask for myself, in relation to the paragraphs 214 to 216, which you obviously take objection to, the findings there against Mr. Andrew, could they in themselves amount to corruption?
No.
And why is that?
Well, because if you boring living task to do, corruption was used throughout the case.
Well,
and
that aside.
Well, a retention of documents in the knowledge that they should be they're privileged and they should be returned is not corruption.
To achieve a benefit for which you are being very handsomely financially remunerated, and therefore you have an incentive.
Which is the context in which the judge made the finding at 592.
Could that not amount to corruption?
Well, the trouble is the judge has found a corrupt scheme in 495 to 6. He doesn't find a corrupt scheme in the earlier paragraphs. And to wrap Mr. Andrew up with P&ID's corrupt scheme in 592 without giving any reasons is clearly a breach of his Article 8 rights.
Just as actually answer the point I make,
I'm sorry.
could that amount to corruption in itself?
Well, it's certainly dishonest.
Yes. And what is corruption? The base level of corruption is dishonesty, isn't it?
Yes. Yes. A finding that Mr. Andrew deliberately kept the documents or deliberately failed to return them because he knew they ought to be returned, and he did so because he wanted to achieve a certain financial outcome, I would have to accept that you could call that corrupt.
So if the judge had said at 592, driven by greed and prepared to act dishonestly, you couldn't complain. Assuming that 592 is done.
Assuming my other grounds of appeal fail, I couldn't complain.
Yeah, no,
Yeah,
understood.
yeah.
But just on this particular
Yes.
argument,
Yes.
you couldn't complain.
No.
Okay.
But any natural reading of 592 would be drawn back to 495 to 6 to the scheme. And nowhere does the judge identify how it is that Mr. Andrew is said to have participated in the scheme, because as you've seen, 495 and 6 deal exclusively with P&ID's conduct. And you will, of course, recall the guidance in Symmetra that judges must deal with apparently compelling contrary evidence. And that's particularly important here because Mr. Andrew consistently maintained he didn't know how P&ID came to obtain the documents. And if you turn to 214 of the judgment at 124, you'll see the judge accepts that. Line 3 to 4. And another piece of compelling evidence to the contrary, it was never alleged that Mr. Andrew knew that P&ID had been making payments to Miss Tiger during the arbitration. And that being so, any reasoned judgment would have to explain the basis on which Mr. Andrew could probably be regarded as a participant in the corrupt scheme, even though he wasn't aware of the bribery.
And as I understand it, one of the bases upon which it is said that the reference to corruption there must refer to Mr. Andrew is because 593 immediately goes on to refer to referring the judgments to the SRA and the BSB in the case of Mr. Andrew.
Yes.
But that paragraph then goes on to make it plain that the matters in relation to which the judge anticipated the regulators would consider the professional consequences are in relation to Nigeria's internal legal documents.
I accept that.
And so if one then looks back at 592, if and to the extent that the reference to corruption there is referring to Mr. Andrew, it is referring, surely one must conclude that it is referring to matters in relation to Nigeria's internal legal documents.
No, because it clearly embraces 495 to 6 so far as P&ID and P&ID is concerned. And it'd be very odd for a judge to use prepared to use corruption to mean two different things in one sentence.
Well, if he was finding that Mr. Andrew had been corrupt in a broader sense, then surely he would be inviting the regulators to look at those matters as well. It would be very odd for a judge making a finding of corruption not to refer that to the regulator. What he refers to the regulator is what he's found. And what he's found...
I mean, if, as you say, I'm picking up that point, if, as you say, this refers to 496 or whatever it is, which talks about the bribery of the witnesses, if that's what he was referring to, he was surely, to goodness, have referred that to the regulator. I mean, in a sense, that's even more serious than the allegations about the documents. That's effectively an allegation that a solicitor was prepared to to participate in the bribery of witnesses to procure the result that his client wanted. I mean, I can't imagine anything more serious than that, really.
The judge made no finding at all about Mr. Andrew using these documents for any purpose. It was merely the retention.
We see merely the
I'm
retention.
sorry, he did. You're wrong about that. He says in terms at 215 that they knew, he and Mr. Burt knew they weren't entitled to see the documents. That decision not to stop it, either by informing Nigeria or immediately receiving the documents, is indefensible. And the reason why they behaved in that way is because of the money they were going to make out of it.
It doesn't say that they made any use of those documents, and the documents are dealt with. I'll come to this in a moment.
But he'd said that previously. The whole point of these documents, they could monitor whether or not Nigeria had found out about the bribery.
That's not a finding against Mr. Andrew. That's a finding against P&ID at 495-6.
What was the purpose otherwise of having withheld these documents?
Well, when I come to ground two, he felt he had conflicting duties, and felt that the proper way of responding to the receipt of the documents that he did not encourage was not to deploy them in any way at all. And the judge has made no finding to the contrary against him. The judge has not held that Mr. Andrew
Well, the judge has disbelieved your client's evidence, and yet he never read them, effectively.
I misheard you.
The judge has disbelieved your client's evidence that he never read them or didn't pay much attention
No, he
to.
didn't say he didn't read them.
But he says in 216, Mr. Andrew suggested in his evidence did not pay particular attention to Nigeria's internal document, did not read them all.
Yes.
Or some of those he's received completely. That I find was not truthful evidence.
Yes.
So the judge's finding there that Mr. Andrew did read and pay particular attention to the documents.
Well, he doesn't say
And then he goes on to find at 217 why they weren't returned. True it is he doesn't mention your client by name, but the clear implication of all that is the judge was finding that your client was well aware why the documents were being retained and didn't do anything to stop it.
Well, when the judgment goes through, I'll come to this on ground two, when the judgment deals with the receipt of the documents and itemises the ones that he thinks are important for his judgment, at no stage does he say that Mr. Andrew put those documents to use in any way or form.
Well, Mr. Andrew didn't. Mr. Andrew was conducting the arbitration on behalf of P&ID, wasn't he?
Yes, but he didn't deploy them.
Can I just answer, what do you mean by didn't deploy them? Because the whole point is you'd keep them and you'd keep them secret, wouldn't you? Because you didn't want anybody to know that you were monitoring how the negotiations were going.
But the judge does not make. I'm sorry. I didn't mean to.
I mean, the fact is that the documents gave P&ID rather, a tactical advantage over Nigeria.
Yes.
Of knowing what the thinking was within Nigeria about, for example, the merits of their own defence or lack of it, about whether or not what level they should or shouldn't settle. It told P&ID that Nigeria wasn't alive to the bribery that was taking place. And that's all. Those are the points that the judge is making in paragraph 217.
Against the judge's findings about the bribery and the monitoring of whether or not monitoring the documents to see whether or not the bribery been unearthed is a finding made against P&ID only. It's not a finding made against Mr. Andrew. And you can't import that finding into 217. The only finding against Mr. Andrews, he knew that he should return the documents, and his failure to do so was indefensible. There's no finding by the judge that Andrew put those documents to any use, and there's certainly no finding that Mr. Andrew used those documents to find out what the other side would do. And if the judge had wanted to make that finding, he would have done.
Going back to 592
Yes.
and 593, may I suggest what might be the proper reading of 592 is the judge is talking in very general terms in 592, and he refers to a combination of examples of what some individuals will do for money. He's not particularly identifying them, and he refers to driven by greed and prepared to use corruption. And I understand that to mean that in this case there are some individuals who've been prepared to use corruption. And then in 593, he then goes to specifics that he will be referring to the regulators in relation to those very specific matters. And I'd suggest that I don't think that does indicate that that the reference to corruption in 592 extends in relation to Mr. Andrew beyond what is being referred in 593.
Well, the language used in 592 is very broad. Anyone reading that, I would suggest, would think that the judge has found that Mr. Andrew is prepared to use corruption. And that requires Mr. Andrew not just to retain documents, it requires him to use those documents either as part of a scheme or part of his own scheme, or sort of one-man solicitor scheme, different from P&ID's scheme.
But as you say, if you read the judgment, the corruption he refers to is matters in which he doesn't implicate Mr. Andrew.
Yes.
And the matters in which he is referring to the regulator is not that corruption.
But it's a very serious finding to make against a professional man, that to say in 592 he was prepared to use corruption.
No, but if that is what we're now discussing, is that a finding he has made against Mr. Andrew? And I have to say, what I'm asking you about isn't it the case that if you just look at it very broadly, you say, well, he's saying that people have used corruption, and then goes on to refer to Mr. Andrew. But if you read it carefully, as I think you have to, I'd suggest to you that in fact 592 isn't referring specifically to anybody, but then the specific things which are referred to in 593 are not the broad corruption that is referred to in 495.
I see that it's a possible interpretation on a careful reading. It's not how the world has read
Well, that
and
doesn't never matter how the world has seen it.
And
We have to interpret the judgment as to and anticipate what the judge meant, not what the Times or with the greatest respect, Mr. Howard, in a chat with one of his colleagues in Chambers, which happens to be put on a podcast, thought that the judge meant. It's what the judge meant. Given that your client didn't invite the judge to revisit the finding, or didn't make an application specifically in relation to 592.
But there's no explanation. Let's say you're right. Let's say your interpretation of 592 and 3 is correct, and that what the judge had in mind in the general observations in 592 was corrupt scheme so far as P&ID was concerned, but wrongful use of documents so far as Mr. Andrew is concerned. The judge is still duty bound, we say, to give proper reasons as to why his finding of what Mr. Andrew did in respect to the documents was corrupt. Now, I was asked questions which said if the judge had put it in a certain way, would that suffice? The judge could have done this. Not what the judge said. The judge has just said wrongful retention. The judge has not said that Mr. Andrew was party to any plan to monitor what was going on. It's just not there in the judgment. You will look in vain for him being party to any plan to monitor what was going on. You will look in vain for any finding as to a specific misuse of a document by Mr. Andrew. The other side try and rely on one in their skeleton argument, but it's a point that doesn't work for them. Because it's a document.
Just on my part, is it not implicit when you are the solicitor with responsibility for the arbitration?
I'm sorry, is what implicit, if I may ask?
That you were, as it were, utilising the documents for the purpose that's set out in 217. Or at least had knowledge of it.
Well, Mr.
Very
Andrews,
strange if the solicitor wasn't aware of it.
sorry, I'm going to get 217 back up.
Sorry.
So Mr. Andrew didn't know anything about the bribery. It was never put to him that he knew about the bribery. It was accepted that he didn't know about the bribery. So 217 is directed at P&ID. It's not directed to Mr. Andrew. The findings about Mr. Andrew in 214 to 216, and nowhere there will you find a finding to justify a finding of corruption on the basis that he deliberately flouted his professional duties because he wanted to gain an unfair advantage in the arbitration. The judge hasn't found that. And on a duty to give reasons, the judge is duty bound to consider Mr. Andrews' evidence, at least to identify compelling evidence to the contrary. The judge doesn't engage with this at all. So, I mean, we read 592, 593 as being a broader allegation than Mr. Andrews than just the documents. I understand the court may not agree with us about that. But even if the court is right in saying that 593 really looked at very carefully, 593 informs 592 so far as Mr. Andrews is concerned, there's still the problem that we have a finding of corruption where the actual findings made against about Mr. Andrew and not PMID do not justify a finding of corruption.
Well, that argument turns on two things with respect. One, and in a sense, we've covered the ground, I think. One is your point that it's referring to Mr. Andrew in 592, and you dealt with that. The other is that when it's talking about corruption, what it's talking about is the bribery of Mrs. Tager and the other people.
Yes. And
it's not using corruption in a more general sense to do, which the court put to you. I think.
Well, corruption appears...
Lord Justice Phillips and Lord Justice Jeremy Baker put to you. Corruption in the sense of acting dishonestly, which clearly was a finding the judge made.
Yes, it was. Can I just say this?
229 is another one. This is the judge's findings in relation to the preparation of Mr. Quinn's witness statement by your client, in which he asked P&ID for a list of which documents had come into their possession officially and which unofficially, so that he could limit references in the witness statement.
Yes.
And as the judge found, that this reflected, at least in part, his recognition that P&ID had been receiving Nigeria's internal legal documents.
Well,
He might go on to say, it also makes pretty clear that he didn't want to disclose in the witness statement any documents that they had obtained, quotes, unofficially, unquote. It might be said, on one view, that is corrupt behaviour.
well, corruption as a word appears 62 times in the judgment. And every single time that it appears, it is in the context of bribery. Bribery with a view to collusion. It's 62 times it occurs. I suggest it's fanciful to think that in 592, the judge is using corruption in a different way to the way he's used it throughout the preceding paragraphs. And is in fact adopting a more limited criticism of Mr. Andrew, particularly when he's given no reasons at all as to... It's not found that Mr. Andrew knew about the bribery. It's not found that Mr. Andrew actually uses documents. I know you're trying to interpret 214 to 216 to suggest that the implicit in that is a finding. We say, no, there isn't. Absolutely not.
What finding?
Some difficult.
Sorry, well, implicit a finding he knew about corruption or knew about
implicit
bribery.
in the finding that the reason he was retaining them was to get an advantage in the arbitration. That is not that doesn't appear.
No, but what does appear is that he knew that his client was retaining the documents, the unofficially obtained documents, for the purposes of gaining an advantage in the arbitration.
Where does it say that Mr. Andrew knew that? I don't think it does.
Well, what else does 229 mean? Why on earth did he ask which are the official ones and which are the
No,
unofficial
because he
ones?
gave evidence about that, and we'll come to that when we get to ground two. He had been a bit uncomfortable receiving these documents. He didn't encourage them, the receipt of these documents. They didn't all go to him. He only got a small proportion of all the documents that were obtained by P&ID. And if Mr. Andrew had been party to some corrupt scheme, you'd expect him to have seen all of them and commented on them. He didn't. He thought that the documents, for the most part, were immaterial, were not helpful, were not relevant, and he didn't want to cause satellite arguments by referring to the unofficial documents, which he'd been assured had been produced by the other side to demonstrate that they were wanting to engage in settlement discussions. Where is Mr. Andrews' evidence about all of this? It's not there. You can't
The
judge.
Where does the judge make a finding about Mr. Andrew not thinking the documents actually were of any significance? Where's his finding about that?
Well, 214
His finding about that, insofar as he makes a finding,
is not part of
is
settlement.
in the first sentence of 216, which he then says was not truthful evidence.
Yes,
So he dealt with it and he's dismissed it.
but he hasn't said what use Mr. Andrew made of them. And to suggest that one can read into
Well, it's a
216...
point that Lord Justice Jeremy Baker put to you. When Mr. Andrew was conducting the arbitration, the idea that somehow he was on one tram line, as it were, in relation to his conduct of the arbitration, and P&ID itself was on another completely different tram line in relation to what he was doing with the document, seems to me to be rather fanciful.
Well, then we go back to 495 and 6, don't we? And then we go back to the total lack of reasons when it comes to Mr. Andrew.
Can I just go back just very briefly to 217, because I rather missed the point. 217 actually, the primary purpose, and I appreciate that in terms it's talking about NID,
Yes.
enable PRD to track Nigeria's internal consideration, merits, strategy and settlement during the arbitration, full
Yes.
stop. And then as an addition, also allowed about monitoring about bribery. I take your point personally about whether or not there was evidence that Mr. Andrew knew about the bribery and the finding behind to pay the jack. But what about the first part of that?
Well, it's a finding against P&ID, and it follows through to 495 to 6, where we have the finding of the corrupt scheme, and nowhere is Mr. Andrews said to be part of it. You can't find someone being prepared to use corruption implicitly. You can't do so and invite this court to have to read between the lines as to what the real finding was. If you're going to interfere so starkly with someone's convention rights and say he was prepared to use corruption, you've got to say in what respects he's prepared to use corruption. You have to identify what the corruption was, and you have to consider evidence that goes the other way. The judge has done none of those things, and we're now left scrabbling around, if I may say so, asking precisely what did he mean by 592. And then you make a very good point about 217, that if Mr. Andrews is meant to be implicated in 217, then he's implicated in 495 and 6, but not mentioned.
Yeah.
And if Mr. Andrew isn't implicated in 217, which is what I say, you're then driven back to 214 to 216, and that is not corruption. It can only be corruption, on your example, if I may say so, if there's a deliberate retention of documents with a view to misusing them with a view to getting financial gain, and that is nowhere in the judgment. Nowhere.
It seems that a very useful thing that could have been done between the 16th of October 2023 and the 23rd of October 2023 would have been for Mr. Andrew, with the benefit of his legal advice, asking the judge to clarify whether or not the reference in paragraph 592 of people being corrupt was a reference to him.
Well, with the benefit of hindsight, of course, it would have been a sensible thing to do, but it wasn't done. And that doesn't follow from that there hasn't been a breach of his convention rights. Because
But
it's
he
not.
certainly had the opportunity to ask for that, didn't he?
But that doesn't get rid of, that doesn't dispose of the criticism of a lack of
We have the
reason.
benefit of legal advice as well.
It doesn't dispose of the criticism of a lack of reasons. It doesn't dispose of the
Well, it does with respect, because if you have an opportunity to invite the court to give further and better reasons for a particular part of the judgment, and you don't avail yourself of it,
But
you
that,
can't come to this court and say, make good the inadequate reasons in the judgment, even though I had an opportunity to ask the judge to clarify them and expand on them, and he didn't.
the judge was effectively asked to do that on the 8th of December, and he declined. Because the grounds of appeal and the skeleton argument in support complained of lack of reasons. So the judge it can't be said against Mr. Andrew that the judge wasn't aware of all of this.
Well, forgive me, the judgment was handed down on the 23rd of October,
Yes.
and you put in written submissions on the 6th of December
Yes.
in advance of a consequential hearing on the 8th of December.
Yes.
It doesn't seem to me that that was a very convenient way of asking the judge to give further reasons for his judgment.
Well, I accept with the benefit of hindsight, one could have approached it a different way, but I'm faced with what is. I can't go behind that. But all I would say, it was made clear to the judge that the criticism of the judgment was a lack of reasons. And the judge would have had an opportunity at that stage, could have adjourned the application, given an extension of time, and given reasons. But he chose not to do so. So I think at 2 o'clock I probably ought to move on to ground 2.
Yeah, I think so. 2 o'clock, please.